Welcome to Major in Law YouTube channel. Today's video is about company formation. Establishing a new company has a set procedure to take out. Promoters are key players in the process of incorporating a company and starting its operations, with their responsibilities and tasks being distinct. They enter into contracts on behalf of the company before registration, resulting in potential legal consequences. A promoter is responsible for bringing a firm into the commercial world and executing essential actions to officially incorporate a corporation. The primary activities include registering the firm at Companies House, entering into pre-incorporation contracts, producing a prospectus for public firms, and appointing shareholders and directors to invest in the new firm. The term promoter is not defined in the Companies Act of 2006. But the judiciary has established standards to determine this. Chief Justice Coburn in Wycross v. Grant, 1876-77, states that a promoter is responsible for incorporating a business and ceases activities when a board is formed. The fiduciary position of promoters. Fiduciary ties exist between principal and agent, creating specific duties for agents to act in good faith and in the principal's best interests. Promoters also have a fiduciary responsibility with the firm, solely responsible for the company's conception and development. Duties and liabilities. A promoter's main role is loyalty and good faith, and they cannot make hidden earnings for personal gain. The corporation can sue them for recovery. Promoters must disclose gains to the independent board of directors, and failure to do so may lead to recession action. In Airlana vs. New Sombrero Phosphate Co., a syndicate bought a mine for £55,000 and founded a corporation, reselling it for £100,000. The company's directors were replaced, and the board cancelled the deal. If promoters failed to provide complete information, the contract is voidable at the company's discretion. However, the right to rescind will be lost if the entity agrees or if the company delays withdrawal. Pre-incorporation contracts. The company's existence is established when a certificate of incorporation is provided by the registrar. However, before the company is formed, promoters can enter pre-incorporation contracts with third parties, such as leasing premises, purchasing equipment, and connecting to utilities. These contracts allow the firm to begin trading immediately after the certificate of incorporation is granted. However, these contracts present a loophole for promoters, as the companies does not exist at the time of the contract. According to contract and agency principles, the promoter, an agent, cannot bind a corporation, the principal, that does not exist at the time of the contract. Some issues were addressed in amendments under Sections 92 of the European Communities Act of 1972 and 51 of the Companies Act of 2006. The common law position. Contract law states that a binding agreement only occurs when parties are present. Pre-incorporation contracts do not have a company at the time of the contract, and the doctrine of privity prevents their company from acquiring rights or responsibilities. Kellner vs. Baxter, 1866-1867, the hotel promoters negotiated a pre-incorporation deal to buy wine, which was approved but later fell into insolvency. The promoters claimed the contract was ratified and passed to the corporation, but subsequent ratification could not absolve them. However, innovation allows promoters to avoid personal liability by replacing the old contract with a new one after incorporation. However, if the company enters into a new contract based on a faulty perception, the contract becomes null and void. Companies Act 2006, Section 51, the UK's first European Community Directive on Company Law has amended a section requiring companies to engage in new contracts on similar terms to pre-incorporated contracts after incorporation. This ensures third parties' interests are protected by making promoters personally accountable. Lord Denning ruled in Phonogramma Limited v. Lane, 1982, that a pre-incorporation contract should exclude promoters to prevent personal responsibility. The clause's scope cannot be reduced to prevent enforcement of contracts signed by individuals on behalf of unformed corporations. In conclusion, a promoter is responsible for creating a firm, completing necessary processes, and holding a fiduciary duty to the company. They sign pre-incorporation contracts on behalf of the company, ensuring they are personally accountable to protect third parties' interests. For more videos like this, subscribe now. To get study materials, visit www.majorinlaw.org.